Sirs, well, attorneys, please help us make sense of all of this that's been happening in the past few days. You're looking at a 2012 story and a new law, the cybercrime law, being enacted several months later, and then a 2019 arrest. Does this make sense to you?
Well, my initial impression was when I first heard about the arrest was the prohibition against ex post facto legislation being enacted, or a law being applied ex post facto. Ex post facto being after the fact. So it is unconstitutional to enact an ex post facto law. It is unconstitutional to apply a law ex post facto. And that was the first thought I had, because apparently the article was posted at a time when the cybercrime law was not yet in effect, although libel was already in force. But they chose to file cyber libel, choosing to apply the law retroactively, even for a few months, but it doesn't matter. So that was my first impression. It would appear that that would be one of two major issues surrounding this particular case involving Maria Ressa and Reynaldo Santos.
Yes, sir. But there are those who argued that it was not retroactive and that it was only being applied to the 2014 or 2015 edit.
2014, yes. And
Story.
again, which is why I said one of maybe two major issues there. That second issue is whether the theory of multiple republication or continuing offense would now be applicable to cyber libel. That's an open question, has not been decided. It's not an element of libel, nor is it an element of cyber libel. So if the DOJ theory, if the prosecution's theory that there can be a prosecution, basically a new period and a prosecution based on a multiple republication or a continuing offense, then you would have the possibility of as many prosecutions as you update, let's say, an online post.
You say theory. Itong concept ng continuous publication, is this a new concept? And if it is new, or even if it's old, is it part of the law? Is it part of jurisprudence?
It's not part of libel law. It's part of the jurisprudence involving the former Subversion Act and rebellion. For rebellion, malinaw yan. The Supreme Court has decided in Umil versus Ramos, involving former members of the Communist Party of the Philippines who were arrested without warrants. They were charged with subversion at that time, and they were charged with rebellion. And the court said the arrests were legal because they were in fact committing a crime, because they were engaged in rebellion and subversion, and both were considered by the court as continuing offenses. So the main point of the court in Umil was that even though you were not engaged in an active act of rebellion, because you were engaged in a rebellion, you could be arrested at any time. That has not been applied to libel or to cyber libel.
Let me clarify as well. While Attorney Te argues that it has not been applied in any libel law, jurisprudence in Soriano versus Intermediate Appellate Court, that is a libel case. And Justice Gutierrez there said that the republication, because the first publication was made here in Metro Manila, and then there was another publication made in Tacloban, the case there, that case was filed in Tacloban. And then Justice Gutierrez said that the republication is actually a doctrine that we subscribe to here in the Philippines. So while it is a third division of the Supreme Court case, it's really not unbanked. It's still, we have that kind of doctrine already in place.
But in that
for
case,
the libel law. But that's 1988 case.
In that case, yes, it's 1988, pre-internet, and you're also referring to two specific places, physical places, which means this is print,
yes,
and so on.
Yes.
In the concept, in the case of Rappler, the concept of continuous publication was reopened in the context of a correction,
an edit,
of an edit, no?
with nothing added to the supposedly libelous article. Yes,
that's their defense.
No. I mean that's an actual fact apparently, because the only thing that was added apparently was a comma or a period. So the question of whether continuing offense or multiple republication
Okay.
would apply to a cyber offense.
So that's a
for example,
new-
cyber libel.
that is a new
That's why it's
question.
called a theory.
That's
And-
a new
and as-
that's a new theory.
Correct,
That
and-
it has to be applied
Correct.
online.
Correct. That's why
Yeah.
I agree with Regie that yes, it has been applied to libel. Libel. Because libel has been here since 1930,
Yes.
since the revised penal code. But and again, it applies to print. It applies to a different format.
case,
Yes, different case. And more importantly, it is not considered doctrine because it's a division case. Only the en banc decisions of the court become doctrine. So that's why it's an interesting legal question, and it's an open question basically, as to whether the DOJ's theory, and I call it a theory simply because it has to be tested before the courts, whether the theory will be accepted by a court, whether the court will sustain it and say, yes, we will now consider this information as being valid, and that the multiple republication theory will now be accepted, and basically there is no retroactive application of the law because you are starting from the 2014 edit, which we will now consider sufficient as constituting a new period to file the libel.
So it's
cyber libel
actually
case.
a gray area, and you would say that the cyber law needs some amendment just to clarify this issue.
Yes, I think that point alone is a very important point to be considered by the court
Because
in
considering-
deciding the libel
yeah.
case against Maria. Now, because of the fact that it poses two questions. First, is there a retroactive application of the law? Second, would prescription under Article 90, which is 1 year for libel, will that apply? Or will there, because it's a continuous publication, there's no prescription yet because even
Forever.
now it's
Or ever.
existing
Forever.
forever.
Forever,
So
yes.
those are the two things that hinge on the answer to that
No,
question.
but based on the dates only, because
Yeah.
because of the nature of publications on the internet, you keep updating.
Correct.
So does this law need revision to specify that you can file based on the date of the last edit?
I
so
think the
that
Supreme
one is
Court-
not that one is not in the law.
Yeah, that one is not in the law.
And
Although
you,
in
you think
Dicini,
it will need a specific provision there to
Personally-
cover this? Because ang dami-daming
Yeah,
ganyan
Personally,
nangyayari.
I do not believe in the Cybercrime Act. I was one of those who
How-
lawyered
why is that?
for
Yep.
petitioners, some journalists,
Yeah.
including Rappler,
Yep.
challenging the constitutionality of the law. Precisely because it unilaterally and just adopts every felony, every crime in the revised penal code and every statute ever written and will ever be written,
Including libel.
including libel, and makes it a cyber offense simply by the use of a computer. No? Unilateral. The offense may have nothing to do whatsoever with the nature of computer systems or a cyber offense or the cyber space, but it now makes it a cyber crime simply by adopting, by putting a computer there as an additional element. Every crime now. So technically, you can have cyber murder, cyber homicide, cyber estafa, lahat. Dagdagan mo na ng cyber, then that's it. No? So wholesale, that's among the questions that we raise. And then, of course, going to very specific offenses like libel. No? If, of course, libel was written during a time when the printed page was king. It's now no longer the printed page that rules. It's really online publications. And so when you talk about cyber libel in relation to the Cybercrime Act, no, ito yung mga hindi na defined. These are the things that they did not define because they simply said, if you commit this felony or this crime with the use of a computer system, automatically becomes cybercrime, and the consequence is the penalty for the original felony or crime is higher. by 1 degree.